Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with there on the signature page of the GAR, Georgia Association of Realtors Purchase and Sale Agreement. There are fill in the blanks for your public buyer and your public seller, their contact information, their address, email address, phone number, fax number, all that kind of information. So the question is, what is required to be filled out in those fill in the blanks on the signature page of a purchase and sale agreement? And how do we know? Well, let's go through the set of instructions and find out. So yes, you heard me say set of instructions. And for those of you who have been in any of my classes or watched some of these videos, you will repeatedly have heard me say, or you will have heard me repeatedly say, that the purchase and sale agreement, your contracts, are nothing more than a set of instructions. They're instructions to all the parties. They're instructions to the buyer on what they have to do to purchase the property. They are instructions to the seller on what the seller is required to do to sell the property. They are instructions to the closing attorney as to how to prepare the deeds and the paperwork. They are instructions to the lender as to how to prepare the loan paperwork and the loan documentation. So, all your purchase and sale agreement is nothing more than a set of instructions. So when it comes to anything, a question that you have regarding your contracts, the first place you should go to is the contract itself, and let's see what the contract has to say. So for today's question at hand is, what contact information for the public buyer and the public seller is required to be on the signature page of a purchase and sale agreement? And why? How do you know? Well, the first thing we need to do is let's look in the contract. And today I am just specifically covering the Georgia Association of Realtors Purchase and Sale Agreement, which is GAR F201. And it states under paragraph C10B under brokerage, that's the first clue we get to as to what to fill out there, what is required to fill out for contact information for the public buyer and the public seller. And what is the role of a broker or affiliated licensee signature? Does the affiliated licensee, do you guys as agents need to sign it? So the first thing we notice is the parties to the contract are the buyer and the seller. The agents and the brokers are not parties to the contract. Neither is the closing attorney, nor the lenders, nor the appraisers, nor the inspectors. The only parties to the contract are the actual buyers and the sellers. So when an agent signs a contract, what does that actually reflect? And that is spelled out, back to what I started to say, in the GAR, Georgia Association of Realtors Purchase and Sale Agreement, Form F201, under paragraph C10B, where it talks about brokerage. The real estate agent broker has a brokerage relationship with the public parties. And so when an agent signs or a broker signs the contract, it states, there's a lot more information in that paragraph, but at the bottom of that paragraph, it states, the brokers herein are signing this agreement to reflect their role in this transaction and consent to act as holder, meaning holder of the earnest money, if either of them is named as such. This agreement and any amendments thereto shall be enforceable even without the signature of any broker referenced herein. The brokers are express third-party beneficiaries to this agreement. Okay, so we're heading down a little bit of a path, but let's see where that path leads us. The first thing is what it talks about, the brokers are signing this agreement to reflect their role in the transaction. What on earth is their role in the transaction? Where do we find that? Well, the role of a broker's the role of a broker within a transaction is disclosed in the purchase and sale agreement in paragraph A, 10, A, and B. where it talks about the brokerage relationships in the transaction. And there is a place where everybody, you fill it in and everybody acknowledges that the buyer's broker is, and you name the brokerage, and is either representing the buyer as a client, a customer, a dual agent, a designated agent, and the same for the seller. The brokerage in the transaction is ABC Realty representing the seller as a client, a customer, a dual agent, or a designated agent. So that is where we find the role of the broker / affiliated licensee in the transaction. The next thing that the paragraph previous to that talked about the broker's role by signing, what that reflects is it confirms the role in the transaction, and it binds the brokerage to fulfill all the responsibilities of holder if the broker is named as the holder of the earnest money. Where do we find that information? Again, let's go to the purchase and sale agreement, and in paragraph A6, it has holder of earnest money. The holder of the earnest money is, and you fill in the blank. And if one of the brokers is named as the holder of the earnest money, then the broker's signature on the signature page affirms that that holder will fulfill all the responsibilities as holder of those trust funds as outlined in the agreement. Now, still doesn't quite get us to the question. Well, let me back up just a little bit more. Broker. You are an affiliated licensee. You are an agent. So all of this verbiage right now talks about a broker signature on the broker's role. Well, under paragraph C5C, under definitions, the GAR contract defines broker as meaning the licensed broker, the brokerage, or its affiliated licensees, unless the context would indicate otherwise. So if you see the word broker, that extends to you as well, the affiliated licensee. You're an affiliated licensee with your broker. So when I choose to bring you onto my firm, or any broker chooses to bring you onto their firm, they are giving you authority to sign contracts in the broker's name, because all contracts, all brokerage agreements, all purchase and sale agreements, all lease agreements, all contracts are in the broker's name. They're all broker contracts. It further goes on to state that just by your signature, you as the agent signature or my signature as the broker, or any broker signature, does not actually bind the parties to terms. And that's spelled out in paragraph C4I, no authority to bind. It goes on and says, no broker or affiliated licensee of the broker, by virtue of this status, shall have any authority to bind any party hereto to any contract, provisions of any contract, amendments to any contract, termination of any contract, or notices signed just by the broker or agent, but not signed by the party, meaning not signed by the buyer or the seller. So just by virtue of your signature as the agent, that does not tie the public to terms. So back to the question at hand. What kind of information do you need? Do you need for the public, buyer and seller? What type of contact information are you required to fill out on a purchase and sale agreement? So we need to dig a little bit further. And let's look under the paragraph where it talks about notices. And that in the GAR purchase and sale agreement is under paragraph C1. And there's a whole bunch of subparagraphs under there. So let's start with paragraph C1C. It says, notice to the broker is the same thing as notice to a client. And it states, when is the broker authorized to accept notice for a client? Except when the broker is acting in a dual agency capacity or a designated agency capacity, the broker, meaning you, the agent as well, and the broker and any affiliated licensee of the broker representing a party in a client relationship, again, as long as it's not dual agency or designated agency, shall be authorized agents of the party for the limited purpose of receiving notice, and such notice to any of them shall, for all intents and purposes, be deemed notice to any party. So it also goes on to say that, again, if it's just a client relationship, just client agency, not designated or not dual agency, not only is the agent authorized to accept notice, but it goes on to say that the broker staff also can accept notice on behalf of the party. So again, the contact information really is for the signatures are binding the parties to terms, but the contact information is for purposes of notice. So if you have a client relationship with the public, and how do you get a client relationship? You have a client relationship with the seller by virtue of signing a seller brokerage agreement, and you have a client relationship with the buyer by virtue of signing a buyer brokerage relationship. Now, we know dual agency is one broker, one agent. That agent has a client relationship with both the seller and the buyer, and you need to check with your broker to make sure your broker allows that. Designated agency is one broker, two agents. Each agent has a signed brokerage agreement, one with the buyer, one with the seller. And the easy way to remember that is the broker has designated agent A to work with the buyer and agent B to work with the seller. If the situation is a dual agency situation or a designated agency situation, or there is no brokerage agreement, there's no client relationship between the public buyer and seller and the broker. In other words, the seller is a customer of the broker or the buyer is a customer of the broker. Then notice must be sent directly to that public person. Okay, let me back up. If it's a customer, notice must be sent directly to that public person in order for notice to have been served per the terms of the contract. That's the same. That's if it's a customer relationship or if it is a dual agency relationship. If it is a designated agency relationship, then notice must be sent to the agent representing the buyer for notice to the buyer, the agent representing the seller for notice to the seller. It can't be just to the broker or just to the staff at the office or the public buyer and seller themselves. Then we go back and we say, well, what is notice? What constitutes actual notice? What are the forms of notice? And in paragraph C1A, again, under the notices section, it goes on and it says, number one, notices shall be in writing, legible, and signed by the party giving notice. We've already covered that. The party giving notice must be the actual public buyer or public seller. You guys as agents, just you signing a document does not serve as actual notice. You can receive notice, but that does not actually bind the parties to terms. So how is notice done? It is done either, number one, in person, number two, by courier or overnight delivery service, or by certified or registered U.S. mail, or three, by email or fax. Okay? You notice nothing says anything about phone. So text does not serve as notice. Voicemail does not serve as notice. Emails do not serve as notice. They're in writing and they're legible, but they must be signed by the party giving the notice, meaning the public buyer or the public seller. So what does all of that mean? Well, when we go back to the signature page of the purchase and sale agreement for the contact information for your public buyer and your public seller, first of all, there's fill in the blanks for you as at the bottom of that as the agent, the buyer brokerage firm, the broker, and same thing for the seller, or the affiliated licensee, your Georgia real estate license number, your phone number, your fax number, your email address, and your physical address. Now, under the buyer and the seller, it has that same information. So obviously they are going to need to sign. So in order for the terms to be enforceable upon the parties, we need their actual signatures. The point that we're covering today is their contact information. It has a place for their phone number and their email address. And it used to have a place for their fax number, but they have taken that out. So do you have to fill that in or not? Well, based on everything we have just covered, the answer is it depends. Are you working with your public person as a client or as a customer? If you are working with them as a client, are you in a designated agency situation or a dual agency situation? So, if you are working with your public buyer or your public seller as a client and it's not designated or not dual, then no, you just need their name and their signature. You do not need their contact information on the purchase and sale agreement, because notice to the broker or the affiliated licensee serves as notice to the party when they are in a client relationship with you and your broker. Now, I will let you know that on the brokerage agreement, your buyer brokerage agreement or your seller brokerage agreement, you need to have their contact information, their physical address, their cell phone number, their email address, and their fax number if they have a fax, because your broker might need to be able to contact them if for whatever reason you are unavailable or incapacitated, because again, they're clients of the broker. So on the brokerage agreements that you turn into your broker, we need all that contact information. But on the purchase and sale, if you're representing your public as a client, notice to you, the agent or the broker, serves as notice to the client. Now, if it is a customer, well, let me back up. If it is a designated agent situation, then you need to have both agents' information, and notice must go to that specific agent, not just to the broker and not just to staff at the brokerage. If it is a dual agency situation, or if the public person is a client, then the only way for enforceability of notices to meet the terms of the notice section of the purchase and sale agreement, you must give notice directly to that person. So if it's a customer or a dual agency situation, then yes, on the signature page of the purchase and sale agreement, you will need either one of those three forms of notice: a physical address, an email, or a fax number. Again, you can have their phone number if you want, but that does not fulfill the terms of notice. And in that notices section, it goes on to say that notice is sent to that information on the signature page. So if you as an agent, if your purchase and sale agreement auto-populates with an email address or your company's fax number, and you don't use those or you don't check those, you need to alter that in the purchase and sale agreement, because notice could be sent to you and to your client and you may not receive it. For example, a lot of company faxes are only monitored Monday through Friday, 9 to 5. So you wouldn't get any notices in the evenings or on the weekends. So it needs to be one of those three: physical address, email, or fax. So again, now, if you are a co-op agent and you see that the broker is working with their side of the transaction as a customer, that does not give you permission to cross a sign. That doesn't give you permission to directly interact with the public buyer or seller, the public person on the other side of the contract. That public person has still chosen that agent and that brokerage with whom to work. It's just that they have decided that the legal relationship between them as a public person and the broker with respect to this transaction is that as customer rather than client. So you would still send notice, documents, so forth and so on to the agent as well, but you must also include the customer's either email address or fax number on that signature page, and you would have to send notice to them as well. So point of practice for you agents, all of this bundled up into short and sweet. First thing you should do, well, maybe not first, but one of the things you should do immediately when you get a purchase and sale agreement, look at the very bottom of the contract and determine or see what has been disclosed. What is the nature of the relationship between the public buyer and the public seller and the broker slash agent with whom they are working. Is it as client, or is it one of customer, or designated, or if it's dual, it's you. But if it's customer, then first thing you should do, or second or third, one of those, is you should flip to the signature page and make sure that you have contact information for the public person that has chosen to work with that broker as a customer, because notices will have to be sent not only to the agent, but also to that customer directly. If it is a client relationship, then all you need is contact information for the agent slash broker working with that public person as a client. Woo! That turned into a little bit longer contract tip than I was anticipating, but I hope that that helped you out. We get calls and emails all the time from agents, so please make sure that you're subscribed to stay up to date with everything real estate. No matter how complicated it may sound, I'm here to make it crystal clear. If you enjoyed this video, you'll love the one on the screen now. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.